of the important things we were asked to talk to you about are the differences between the DPA 98, which you're familiar with, and the GDPR, which is the new thing that's coming in on the 25th of May 2018.
Is it European law?
Yes.
And therefore binding on public authorities?
Yes. It's EU regulation, which means there's no Act of Parliament necessary. It just comes straight into force on the 25th of May 2018 and has direct effect. The regulations will apply to organisations offering goods and service regardless of payment in the EU, and also to any organisations outside of the EU that are processing data belonging to EU citizens. In terms of the principles that underpin the GDPR, under the DPA there were 8, now condensed down to 6. Processed fairly, collected for specified, explicit, legitimate purposes, adequate, relevant and limited to what is necessary, accurate, kept up to date, in a form that permits identification of data for no longer than necessary, and processed in a manner that ensures appropriate security of the personal data, including protection against unauthorised and unlawful processing. And it's meant to bring about cohesion through the EU, deal with subject access requests. PII has expanded. Significantly, we now have big, potentially enormous financial penalties associated with data breaches. 4% of turnover is sort of for the most serious breaches.
The biggest potential abuse of this sort of, of data and the explosion of data is in commercial organisations. They're the ones who are busy selling on lists for direct marketing purposes, etc., etc.
Data is being used as currency. And therefore fines reflecting the breaches because of that trade in people's information. Why change? Creates an onus on companies to understand the risks that they create for others and to mitigate those risks. And for those that are interested, what about Brexit? I'm sure you know the answer, basically. We are obliged because it's going to be enforced before we come out, and therefore it's applicable.
The difference, if you want to sum up in a few sentences, between this regime and the old regime is this regime requires far more thought and conscious planning and also documentation. Because not only do you have to comply with these principles, you also have to keep records to show that's what you're doing, that you've thought about it in advance before you've done the data protection. And that, I think, is the really big difference and why it's going to be a lot more onerous for organisations.
What is a PII, personal information? Full name, home address, email address, social security number, passport number, driver licence number, card number, date of birth. These are personal identifiers, and this is the sort of data that you are charged, this is all about. You're only concerned with what really makes the individual person identifiable. Special category data or sensitive data, which is particularly relevant to you in your work. It's data which is more sensitive and so needs more protection. Essentially, racial ethnic origin, political opinion, religious or philosophical beliefs, trade union membership is sensitive data. Processing of genetic data, that's new. Biometric data, that's new. And data concerning health, concerning your sex life and sexual orientation. But of particular relevance to you is processing is carried out in the course of its legitimate activities with appropriate safeguards by a foundation, association or any other not-for-profit body with a political, philosophical, religious or trade union aim, and on condition that the processes relating solely to the members or to former members of the body or to persons who have regular contact with it in consideration with its purposes, and that the personal data are not disclosed outside that body without the consent of the data subjects. So there's a specific reference there to trade unions. What's important is that in the past there were things that you did with data that was perfectly acceptable, and as long as you had a good reason for it, I suppose in a way you could justify. Now you have to have a reason that sits within the 6 identified and stipulated basis for lawful processing. There is consent. What is new is that with consent is that you can't, this kind of tick box approach, gone. It's a conscious decision, opt in, opt out, be very clear about it. Vague or blanket consent is not enough, be clear and concise. Name any third party controllers who will rely on the consent. Make it easy for people to withdraw consent and tell them how. Keep evidence of consent, who, when, how, and what you told people, and keep consent under review and refresh it if anything changes. Contract will require a specific, again, detailing, specifying what it is, how the information is being used, and requires consent before that can happen. Legal obligation, again, in terms of the difference between the DPA and the GDPR, very little difference. Vital interest, health and safety. Vital interests, again, very similar to the old condition under the DPA, not a massive change, be aware of it. Public task. This is new, apparently, but it's similar to the old condition for processing for the functions of a public nature in the Data Protection Act. One key difference is that the GDPR says that the relevant task or function must have a clear basis in law. Legitimate interest, it's likely to be appropriate where you use people's data in ways they would reasonably expect and which have a minimal privacy impact, or where there is a compelling justification for the processing. Individuals have the right to access their personal data and supplementary information, and what they're entitled to be told is confirmation that the data is being processed, access to their personal data, and other supplementary information, and this corresponds to the information that should be provided in a privacy notice, which you will find under Article 15. And the GDPR clarifies that the reason for allowing individuals to access their personal data is so that they are aware and can verify the lawfulness of the processing, and that's in Recital 63. You must provide a copy of the information free of charge.
The right to have information provided to them in a particular manner, that's what's called data portability. So that means when someone makes a data a subject access request, you now as an organisation, well from the 25th of May anyway, you're going to have to provide that information in a simple, straightforward, electronic way to the person, as opposed to the way it used to be done with large numbers of emails and documents and so on being provided.
Previously under the Data Protection Act, a paper file would fall within the regime if it was a relevant filing system. Has that now been done away with? Does the GDPR apply to all data, no matter how it's held?
My understanding is it applies to paper files as it does to electronic held records.
Right to rectification, as common sense would say, if it's wrong, there's a right for it to be corrected. It's important to note that if you are told that data is inaccurate, you've got to stop processing it until you find out if the individual's assertion about the accuracy is correct. So you can't carry on and then be proven right later, which I think is incredibly important. Stop and then establish whether or not the information is in fact correct or otherwise. And you've got to respond within a month, which isn't a lot of time. The individual can test the accuracy of the personal data, objects to the processing. The processing is unlawful, but the individual opposes erasure and requests restriction instead. If you no longer need the data, but the individual requires the data to establish, exercise, or defend a legal claim. And you need to review your position to ensure that you're able to determine whether you may be required to restrict the processing of personal data. Right to object. You can only object in particular circumstances, and if, for example, it's a public task or vital interest, then that right to object may well be limited, so keep a lookout for that. And, of course, the right to be forgotten. Particularly relevant, as we will come on to, for perhaps for young people.
It occurs to me that members may want to use that in relation to the kind of vetting checks that employers carry out on teachers, and they do a DBS check to find, and sometimes it reveals that there have been allegations, for example, made against a particular individual, and it comes up in the DBS check. Now, it's an allegation, it's not a conviction, it's not a caution. And I can imagine that members would want to use the right to be forgotten to argue that the police should be getting rid of that information.
Provided the data is retained by the DBS for lawful processing purposes, legitimate, a legal obligation, or possibly even a public task, it seems to me that your members are going to be stuck. There are limitations on those rights where there's a public interest in maintaining that information.
The right to be forgotten isn't sort of blanket right that applies to all data. There's limitations on that right. And it doesn't apply necessarily to where data is retained for either purposes of a public duty or public obligation, or for a legal obligation, for example, a statutory provision underpinning the disclosure and barring service. And so in those circumstances, I think what your members could rely on probably is the same sort of arguments that in some ways apply now. Is it necessary still to retain that information? I mean, that information is being retained, isn't it, for the purposes of child protection. And if, you know, the more out of date it becomes, the more you can argue it's no longer necessary for those purposes for that information to be retained. And I think probably in those circumstances you might be able to argue that it should be erased.
What I think is important about this particular provision is that once you've exercised that right, the data controller has got to let everybody know to whom they have sent that data that they should remove it from their servers or from their systems or whatever.
We all get phone calls, third-party people, you know, we got your data from this person. So what if I, again using the phone contract, it's finished, it's terminated, we're finished there. But I keep getting calls from other people who, is there a fine for that company the original company who had my data, because obviously they passed it on?
Yes, there was a breach.
Right.
There's a data breach.
Right.
But there's this idea of it being necessary to retain the data. And an important principle is if once that necessity has gone, the contract's ended, or you didn't take out the quote, or you didn't buy with them, or whatever, there's no need for them to retain your data. And so you can simply say, I want you to remove it. And if they've shared it with various other people, it's got to be removed across all of those. So it's really quite important that you don't have to leave your data. And it's good that you mentioned the phones, because of course we know what happened with TalkTalk last year or the year before, who ended up paying a huge amount of money. But it would be more, actually, I think, under the current regime for a similar kind of mistake. So if you are an ex-customer and you don't feel the need for them to retain your information, you can be forgotten.
What, if any, impact will this have on our ability to share, say, lists of members at schools with the workplace rep in the school?
It does raise a really important question in terms of there being same data for different purposes, and you need to establish what your lawful reason for processing it is in respect of each of those. So arguably, I think that if you were dealing with a situation where it's for the purpose of communicating internally within the union membership, or it's in a mutual interest, you may well be able to apply on explicit consent.
Schools are going to have a designated data protection officer. The reason for that is, firstly, they're public authorities. Certainly schools in the state sector are. But also schools, if you look at the reason why you need one of these under this regulation, carry out large-scale systematic monitoring of individuals. Well, certainly schools in the public sector, I know, do that. You're going to have a once-only chance before the thing comes into effect to assess the personal data that the school processes. Each school will have to do this. And of course, in future, every time you collate and process personal data, the new regime requires, as Alfie says, you to think about in advance why you're collecting it and why you're doing it, and then to document those reasons. in order to show that you've complied with it. And these records can be required by the Information Commissioner's office, and so it's important that you do this, and the potential penalties for non-compliance can be extensive. Schools are primarily, I think, going to be covered by public task, particularly maintained schools will be covered by the heading of public task. But if that's not sufficient, if it's not a public task basically means it's necessary to perform a task in the public interest or for their official functions, and so when you collect data in relation, for example, to pupil tracking data, then I'm sure that's that's part of the school's official function, and that's going to be covered by that. But some types of data may not be covered by public tasks, and so schools are going to have to think, well, is there any other reason why we need to hold that data? The school's going to need to ensure it's got proper policies and procedures in place for dealing with breaches. Some breaches don't need to be reported, but if there's a risk of adverse consequences to individuals, then it needs to be reported both to the Information Commissioner's office and, if there's a significant risk, to the individuals themselves concerned. And Information Commissioner's office, it has to be reported to in 72 hours. And individuals without unreasonable delay, which I would imagine will be probably interpreted in a very similar way to the 72 hours. So staff are going to need to be trained in how to deal with breaches. What is a breach? How to deal with breaches? Who they have to report any breaches of in the collection and processing of personal data to.
Sometimes, people can act maliciously, or ex-employees, for example, can act maliciously. Sometimes, I think in practice more often, it's a sort of a mistake that is made by someone which leads to sometimes major loss of data. But just saying it's a mistake is not much of a defence, because you have to, as Alfie was saying, you have to show all the things you have done to avoid the mistake happening in the first place. And that's a lot, I think, of what we have to be conscious of.
Obviously, anyone that's has got access or is processing sensitive data, I'm assuming we need to train them, but I'm assuming this is an ongoing training requirement, that it's not just doing one lot of training, that we've actually got to put this part of our kind of corporate training programme, that every year we're doing refreshers or updates for any staff that are processing any data, whether it be for members or whether it actually be for staff.
The requirement certainly is to have a data processing officer.
Mm-hmm.
Organisations such as schools, but I think other organisations, probably trade unions, will certainly have to have one as well. I'm sure any who's already got one, I would imagine, or more than one. Training for other staff will undoubtedly be important, because you need to be ensure that as an organisation your staff are going to comply with this regime, because the consequences are potentially be a lot more serious than the old Data Protection Act. And so I think, whilst it's an absolute mandatory requirement, I think it would be very wise for organisations, including schools, to ensure that their staff are properly trained in the requirements under this regime. And obviously one of the tasks of the data control officer would be to ensure that staff are complying, and also I think to facilitate staff training in data protection. I know just from my own local area, that the NUT and NUT members are involved in all sorts of local campaigns which will involve people, no doubt recording and collating and keeping people's data, which effectively records people's political views. And many of those may be caught by this regime, and so I think members need to be alerted that the days when activity in a labour movement organisation like a trade union, you could keep all these records without thinking twice about it, really, and I think are gone. And unfortunately we are going to have to think about that side of our activity, as well as the sort of more professional activity which many of your members will be involved with, and they need to be at least alerted that those sort of campaigns, potentially, and the information lists they keep, and members' lists they keep of those campaigns, may well be caught by this regime.
How the GDPR may impact on the union's ability to obtain workforce-related data for bargaining and negotiation purposes. So, I don't know what your thoughts on that question might be.
I suppose it will be for the union to decide whether and in what circumstances
access to personal data is necessary for that purpose.
Increasingly, our pay and bargaining department is coming up against a lot of obstruction from some head teachers who refuse to disclose pay progression data, for example, on the basis that the school is so small that if they disaggregate information by reference to race, gender, disability and other protected characteristics, the individual will be identifiable. So data protection is being used as an obstruction to that information.
Once you've got that information, you can in fact anonymise it, even with the smallest of schools, I would have thought, in order to make the information non-identifiable. So you've got to find a workaround. You've got to sort of find a way of picking up on the key aspects of information that you need in a non-identifiable way, and try that response. The other approach you could take would be to possibly go to consent in terms of the members at the schools and see if they will actively agree to have their information disclosed for that purpose. That would be another way around it.
But that doesn't mean to say the school can't disclose it necessarily. I mean, there are, if it wanted to, it could. Consent being one way, possibly a legitimate interest of a trade union as well. If they say that's another reason, both of the school and the trade union in collective bargaining to disclose that information. That might be another way of dealing with it under this new regime.
I have to say that your membership must be extraordinarily expert at responding to detailed and fundamental changes in a short period of time, so I'm sure they'll find this relatively...
With our teachers, though.
Your teachers, I'm thinking about the teachers, but you've had a promise, haven't you, that there are going to be no more
Teachers
changes?
as well.
Yeah.